Hello, everyone, and welcome to Legal Tech Corner. Today, we are going to talk about a foundational topic in legal field: formation of contracts. We will start with the aspects of the legal part of the topic, and we will move to the legal technical perspective of it. So, let's start with the understanding of what is contract. Contract is an agreement that gives rise to obligations which are either enforceable or recognized by law. So, this is the main way of how we objectify our daily promises and expectations. For a contract to be valid, it needs to have three components. The first component is the agreement between parties. Second one is intention to form legal relationships. And then the third one is consideration, something of value to be exchanged between parties. But a contract starts from an offer and ends in theory with acceptance. So let's just break down this both sub areas so that we understand how the full formation of the contract starts and ends. The offer is a proposal. It is coming from the side of one party offerer, is being sent or made available to the other party offeree, which is then accepting the offer if they wish so, and this acceptance will bind the first party, the offering party, to these terms and conditions which are part of the initial offer. An offer can be made in several forms in writing. It can be also spoken out loud, and it can have a form of any action, which should be complete, operable, and contain serious intention to form this binding relationship upon acceptance. Now we are moving to the final point of unconditional consent to the terms of the offer. And this is the point when it happens. This is the point when contract starts to get its final legal shape. But is acceptance and offer enough to form a final legal contractual relationship? We need to pay attention in this case to the intention of the parties. There should be clear intention that both parties are meaning to enter a legal binding relationship, which is not just a casual agreement between parties or domestic arrangement between them. And the existence of this intention will be assessed by the court based on the facts. This brings us to the last vital element of the contractual formation, which is consideration. As I've already mentioned, it is something of value to be exchanged between parties. And we're thinking of an action, doing something or giving something. For example, giving money for goods or for provided services, or completing any action. As I've mentioned, providing services is another something of value that you can exchange. But it's not always about the specific action or any specific activity to be done, but also the promise of it. So you can also exchange the promise, and the consideration part will be covered by that. This is the point when we are transforming the promises into obligations. Beyond these three core elements, there are additional elements which may play a role in the enforceability of contract, depending on various situations. So, firstly, we have capacity, which is the legal ability of party to enter into contractual relationship. If a party is mentally incapacitated, that will make the contract invalid and will exclude its enforceability. Then we're moving to consent, which is also vital part, especially to understanding whether the acceptance or offer have been provided freely. We need to have freedom where there is no one who forces for a party to accept the terms and conditions through duress or undue influence. And as a next point, we have legality of a contract. And this goes towards the whole purpose of the agreement, which should be legal, not contain any illegal clauses, terms, and conditions, and also does not go against the public policies. And the last point for these additional contractual elements, we have certainty. The terms and conditions of a contract needs to be certain, definite, clear, and complete. Otherwise, they may force the contract to be declared as void. This example is reflected in the case of Scammell and Nephew versus Austin, 1941. So in this contractual formation, we also need to pay attention to the form of contract, because although we receive the freedom of the form of contract, it can be in writing form, it can be spoken aloud, but in some cases we must follow strict certain form of contract, for example written form in case of specific contracts like deeds and guarantees. We can also have form in another format depending on the structure of obligations, which brings us to the type of contract. We have unilateral contracts, which give us only promise from one side. One party gives the promise to, for example, deliver a reward if a lost pet is found and returned. In this case, the second party who is accepting this offer does not provide any acceptance in the meaning of exchange, but they are just completing this action which is required in the offer. They are performing action, and by performance, without any communication, without any extra step, they are accepting the offer. In the contrast to this, we have the bilateral contracts, which then define the mutual relationship, mutual exchange of promises between two parties. This happens, for example, in cases when goods are sold or services are delivered and there is payment for both of them. Now let's talk about various statuses of contracts and how law treats different statuses based on various circumstances. So the first status is void contracts. The contract is void, and it's considered in this case as non-existent, as if the contract hasn't ever existed. In this case, anything exchanged between parties needs to be returned, and the original owner of the goods, if they are resold, needs to recover the exchange and resold goods. If the contract is voidable, then the contract is treated from the beginning as a valid contract. But the parties have choice. The choice to cancel the contract and exchange or return anything that was exchanged between parties. So the money that has been paid for the goods should be returned to the original owners. But if we have situation where before declaring a contract void, a voidable contract, before it is declared void, the goods are resold, then the original owner may not be able to recover these resold goods. And in the last form, we have unenforceable contracts. This type of contracts they are considered valid, but in theory. So the court will not be able to enforce them if one party breaches this agreement. So one party cannot sue another party to perform the obligations, to enforce the completion of the promises, and the original owner of any resold goods or exchanged um, values will not be able to recover or reclaim them. So if we think of the contracts as the source of rights, we're not just referring to them as obligations, but also rights that derive from contracts. We have two perspectives for this. The first one is rights that are personam against person. So the contracts by default generally form this type of rights. These rights do specify specific group of people which is involved into contractual relationship, which is party of the contract, and this category of people can be only subject for any claims or enforcement for obligations. Let's say if we are hiring our neighbor to paint a wall, building, or fence, then they have to complete their obligations. If they are not doing that, we can enforce them to do so, but only the neighbor. So we cannot enforce this obligation towards anyone else. But if we think of property law, the rule here, in contrast to personam, is different. We have the rule of rem, which is the claims against the world. It is translated from Latin. And in this case, the interference of any party into your property can trigger your ability to enforce their obligation to stop, for example, building any construction on your territory. This is how we transform or convert the contractual relationships into obligations. And this is how the law is governing those relationships. Since we have covered the technical, the legal part of this topic, the contract formation, we can now move on and zoom in into the technical part of it, how legal tech is transforming the management, building of contracts, and any enforceability aspects of it into technical, automated, digital approach where we can have more secure, time-stamped environment. Let's start with the process of contract formation. Traditionally, we view this process as an offer, acceptance, signature, everything on paper, everything in physical shape. But digital tools, automating tools are changing this by bringing everyone, every negotiating aspect of this relationship into one single platform. And they are giving a chance for automation of the life cycle of the contract formation. How we are sending the offer, how the acceptance is tracked, logged, and timestamped, how we are tracking the intention with audit trails. Everything happens in automated manner and helps us to collect evidence in the future for the court. This brings us to consideration, something of value to be exchanged, but in a digital field. We are thinking of the integration of payment systems as just an additional layer of automation. But in fact, this is some kind of a guarantee layer that we can link our obligations with real life outcomes. We're able to do smart verifications in order to make sure that all the elements of the contract are controlled, are secured, and timestamped. This brings us to AI and drafting field, which gives us opportunity to review hundreds of thousand documents, just scan them and search for any missing components. This missing components can include, for example, vague abstract formulations, uncertainty in the clauses and the contracts. And we have another layer of validation, making sure that all risks are flagged and that unenforceability is directly noticed by the lawyer through the automating tools. Then we have the smart contracts. Smart contract is a written type of contract, but not with pen and paper, but with code. And this code makes the conditional validation of any actions that are conducted controlled and automated. So if an obligation is completed, the reward can be automatically delivered to another party. When we think of the capacity that we discussed earlier, we may look at the verification and identification of personal data, of personal part of involved parties. For example, we can use the KYC tools, the know your customer tools, which create the layer of validation whether the person or people who are participating in the contract are legally able to enter this relationship. And this will help us to avoid any fraudulent activities, and also protect vulnerable users. Legal tech can also solve disputes. We have dispute resolution, where if contract is challenged, if there is claim of duress or undue influence, we can look at the metadata and historical logs of any negotiation, of any activity, and make sure that everything, what happened in the negotiation phase and the formation phase, is collected as evidence for the court. This is how legal tech is reshaping the building and management of the contracts. It makes the whole process faster, cheaper, gives significant transparency to the formation of contract, and also delivers a large portion of security to overall process. This was all about contract formation. I hope you have enjoyed the video, and we'll see you in the next episode. Thank you.